So Brad, when you're getting deposed, if you're an estate planning attorney, who's the holder of the privilege?
It's a good question. There's a lot of case law on that issue. You'd think it would be simple. Who's the holder of the privilege? It's the, well, first of all, if the client's alive, it's the client. What if the client's incompetent? Like, who holds the privilege? So there's two different issues. One is who holds the privilege when the client is alive, and who holds the privilege when the client is deceased. When the client is alive, it could be held by, obviously, the client, it's him or herself, or it could be held by another person who may be appointed by the court. But the problem is where you have a client who is alive and is still vocal and can communicate, who says, I hold the privilege, but then you could have a family member that says, oh, no, that person doesn't hold the privilege because they're not competent. So if you're an estate planner in that situation where the client's alive, what do you do? Well, I think what you do is first of all, you want to see whether the parties can agree to something, because usually there's a dispute going on and there's lawyers involved. My go-to advice to an estate planner, if the client is alive, is you're going to go with the client, number one, like that's your main thing. If you have any questions at all about the competency of the client, you still have to go with what your client says. But sometimes you're going to have to maybe seek court involvement, or you're going to want to get involved with the doctor's reports and things like that, because some estate plans, they say that if this person, this trustor, is deemed incompetent by two doctors, then that's it. Sometimes the estate plan will actually have provisions in there that says, what if you have the two letters, but the trustor doesn't agree,
right? And
the trustor doesn't want to give up. The trustor says, I'm fine. These kids are trying to take over my estate. So obviously a court order is the gold standard, but other than that, you want agreement between the parties. And if you can't get any of that, then I would just hold back, not side with anyone. But I know that there's law that says that even if your client's incompetent, you still have to put your client first. So that's if they're alive.
Right. What if a client has deceased? Who is the holder of the privilege, and what should you be thinking of? Okay,
so there's evidence code sections that talk about this particular issue, and the main part of the evidence code you want to go to is evidence code 950 through 962. And if I was an estate planner, I would want to read those and know those. It would take you maybe half hour to read through those and make yourself notes. We have internal cheat sheets that we have, but you have to know those code sections, because code section, looking at 953, specifically talks about who is the holder of the privilege after somebody passes away. And it's not super clear. Basically, it says if there's a probate opened, the personal representative of the probate estate is the one who holds the privilege. But I've had cases where there was a probate open, but then the probate got closed, and now we have this issue come up. Who's the holder of the privilege? That's a tough question. It's not always straightforward. So again, you might want to hire a lawyer, you might want to research it yourself, or you might want to just kind of get court involvement in this, because the holder of the privilege is a big deal, and it may not be who you think it is.